This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to talk about uninsured and underinsured motorist coverage and why an untimely suit seeking underinsured motorist benefits was dismissed, and that the judgment in favor of the insurer happened because of the plaintiff's sloth. Michelle J. Pollard appealed from the summary judgment rendered by the trial court in favor of the defendant, Geico General Insurance Company, on the plaintiff's complaint seeking to recover underinsured motorist benefits. On appeal, the plaintiff claimed that the court improperly determined that the accidental failure of suit statute, General Statutes section 52-592A, did not apply to revive her otherwise time-barred action. In Michelle J. Pollard v. Geico General, the Court of Appeals of Connecticut on September 6, 2022, dealt with the argument from the defendant that judgment was appropriately rendered and asserted as an alternative ground. Geico contended that the plaintiff's action was barred because she failed under the terms of the party's insurance policy to commence suit timely or to invoke the policy's tolling provisions. The plaintiff alleged that on September 17, 2012, 10 years ago, she was rear-ended by a vehicle operated by Norma Rivera while operating her automobile in a drive-through lane of a fast food restaurant in Hartford, Connecticut. And as a result, she suffered injuries and incurred medical expenses. She alleged that Rivera's insurer paid her the full liability limits under Rivera's automobile insurance policy, such that coverage under Rivera's policy was exhausted on or about June 9, 2016, 4 years after the accident. She further alleged that she had not been sufficiently compensated by Rivera's policy and that, pursuant to the insurance policy between her and Geico, the Geico was required to provide her with underinsured motorist benefits, but Geico refused. In April of 2019, the plaintiff sued Geico pursuant to the accidental failure of suit statute. The defendant filed a motion to strike counts 2, 3, and 4 of the complaint, which the court granted on February 13, 2020. Leaving only count 1, in which plaintiff alleged that the defendant breached the contract between the parties by failing to provide her with underinsured motorist benefits in relation to the September 2012 collision at the fast food restaurant. Geico moved for summary judgment and contended that no genuine issue of material fact existed and that 1. The plaintiff could not bring the present action for underinsured motorist benefits pursuant to the accidental failure of suit statute because the non-suit in the 2016 action, which she had brought against Geico, was for disciplinary reasons and was not a matter of form. She failed to respond to discovery. And 2, the plaintiff failed to bring an action within 3 years of the date of the accident and failed to invoke the tolling provision of the insurance policy by providing the defendant with proper written notice of a claim for underinsured motorist benefits, and therefore the present action was time-barred. The court, Justice Cobb, granted the defendant's motion for summary judgment on the first ground after determining that no genuine issues of material fact existed and that, as a matter of law, the accidental failure of suit statute was not applicable. The Court of Appeal, analyzing the issue, stated that according to Connecticut General Statutes, Section 38A-336, paren G, close paren, paren 1, close paren, quote, no insurance company doing business in this state may limit the time within which any suit may be brought against it on the underinsured motorist provisions of an automobile insurance policy to a period of less than 3 years from the date of accident, provided in the case of an underinsured motorist claim, the insured may toll any applicable limitation period, A, by notifying such insurer prior to the expiration of the applicable limitation period in writing of any claim which the insured may have for underinsured motorist benefits, and B, by commencing suit or demanding arbitration under the terms of the policy not more than 180 days from the date of exhaustion of the limits of liability under all automobile bodily injury liability bonds or automobile insurance policies applicable at the time of the accident by settlements or final judgments after any appeals." Close quote. Well, the court noted that it was undisputed that the plaintiff commenced an action for underinsured motorist benefits outside the 3-year limitation period. There was no genuine issue of material fact. The court concluded that the plaintiff failed to provide the defendant with written notice of her intention to pursue an underinsured motorist claim as required by Part A of the tolling provision of the insurance policy. The October 1, 2012 letter, which was sent by John A. Sodipo from a law firm Jacobs and Sodipo to the defendant, which plaintiff claimed allowed her suit to go forward. Yet the letter contained no reference to a potential claim for underinsured motorist benefits. The trial court determined that the notice was insufficient to comply with requirements of the policy and that the notice requirement in the policy contemplated specific reference to a potential claim for underinsured motorist benefits. That language plainly and unambiguously required the insured to inform its insurer not merely that it is pursuing a claim, but rather that it is pursuing a claim for underinsured motorist benefits. The insurance company needed to be notified in writing that there's a possibility that a claim will be brought for underinsured motorist coverage. In the present case, the court concluded that no genuine issues of material fact existed regarding the plaintiff's failure to satisfy Part A of the policy's tolling provisions. The October 1, 2012 letter stated only a potential claim in general and did not specifically state that the plaintiff may have a claim for underinsured motorist benefits. Geico satisfied its burden for summary judgment with respect to both the 3-year limitation period, which was undisputably not met, and the statute's tolling provision. The tolling provision of the insurance policy requires both that the plaintiff, 1, provide written notice to the defendant within 3 years of the date of the accident that she may have a claim for underinsured motorist benefits, and 2, commence an action within 180 days from the date of exhaustion. Because both requirements of the tolling provision must be satisfied, the failure to meet either requirement renders the tolling provision inapplicable. Accordingly, Geico, demonstrating that, as a matter of law, the October 1, 2012 letter failed to satisfy the requirements of a written notice of claim for underinsured motorist benefits under Part A of the policy's tolling provision, was entitled to summary judgment. The grant of the motion for summary judgment on the ground that no genuine issues of material fact exist, that the plaintiff failed to bring suit within 3 years and failed to toll the limitation period in accordance with the insurance policy, was obvious and necessary. In my opinion, there is no excuse to sit on your rights for underinsured motorist coverage for more than 6 years. Simply stated, an insured loses the right to benefits of an insurance policy by sitting on those rights past the private limitation of action provision of the policy and by failing to comply with the statute that would have allowed her to toll, that is, stop the running of the limitation period. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who asks at zalma.com/blog, and the video, which is available on both rumble.com and on youtube.com. If you found this video to be interesting or useful to you, please advise your colleagues and suggest that they also subscribe to the blog and to the videos. Thank you for your attention.